Good afternoon, all. We're just going to leave it another minute or two, see if anyone else joins before we start. So please bear with us, and we'll get cracking in the next minute or so. Thank you. Right, good afternoon. Thank you for joining us. It may well be that we have a few more join, but we thought we'd get underway. So thank you for giving up your time this lunchtime on a Monday. My name is Graham Black. I'm a partner in our private wealth and inheritance team with a specialty in sort of capacity matters and powers of attorney and course protection applications. And this is my colleague Holly, who's a trainee in our team, and she works with me on a lot of the matters that I'm dealing with. And this afternoon, it is now afternoon, we're going to talk to you through powers of attorney, creation of them, and how they may work, and the need for registration or otherwise. So there will be an opportunity to ask questions. So please do type your questions into the chat and we'll answer those at the end, because I think you're all muted and I don't think you can come off mute the way that this is set up. So please do type in the chat any questions and we will answer those. We'll answer those sort of across the video link rather than typing them into the chat. So we will start, and then please do ask questions and we'll answer those for you at the end. So where we're going to begin is we're going to begin by looking at enduring powers of attorney. Now, most people are expecting to talk about lasting powers of attorney, and that's absolutely fine. Enduring powers of attorney were created previously. You can't create any new ones any longer, and they had to be validly executed before the end of September 2007. An enduring power of attorney was a very short document, maybe 4 pages long. We used to see clients do their wills and their EPAs, as they were called, at the same time. An enduring power of attorney, if you have one, or if your loved one or anyone that you know has one, they are still valid. So there is a misconception. Clients come to us and say, well, I've got an enduring power of attorney, I need to revoke it, or I need to do something different with it. As long as the attorneys are still the attorneys you would choose to use if you were creating a lasting power of attorney, then the enduring power of attorney is valid as long as it was executed before the end of September 2007. So that's always worth bearing in mind. Your attorneys under an enduring power of attorney can only ever make decisions which relate to property and financial affairs. There was no scope for any form of power of attorney to create an entitlement for people to make decisions around health and welfare matters until after September 2007, when the lasting powers of attorney were brought in, created by the Mental Capacity Act in 2005. So any enduring power of attorney does not give an attorney any authority to make decisions relating to health and welfare matters, but only property and financial affairs. But they have the same range and remit of powers in relation to property and financial affairs as a more up-to-date lasting power of attorney would have. Key thing with enduring powers of attorney is that if the donor of the power, so that's the person who's granted the power, has got capacity still, has the capacity to manage their own affairs, they may turn around to their attorneys and say that they would like them to manage their property and their finances for them. They may feel as though they're missing those the bills that need paying, and they're getting red reminders from BT, for instance, and they feel as though they're under pressure to try and remember to do these bits, but they're not always keeping up. They can ask their attorney or their attorneys to arrange to settle all of those bills. They can have them operate their finances, they can have them operate their accounts and be the key point of contact for financial decisions, even if the document hasn't been registered, as long as they retain their capacity. If they do not have capacity, or if the attorneys feel as though the donor is starting to lose their capacity, then there is a requirement in the enduring power of attorney for the attorneys to apply for the registration of that EPA, so that the attorneys then have the authority effectively of the court to carry out those transactions. And in a registered document, a registered EPA is something which organisations will recognise much more freely, and they'll be better at dealing with than an unregistered EPA, which, although is fine to use, as long as the donor has capacity, you will find that you run into more problems with the organisations as they're less familiar with seeing them, particularly as they ended 18 and a half years ago. So that's a little bit about enduring powers of attorney, because one of those things that we do get asked a lot about is this still valid? Yes, it is, as long as it was properly executed, and yes, it can be used, and it may well be that that is an absolutely perfectly acceptable document to retain, to then create maybe a health and welfare lasting power of attorney next to that, rather than having to update the enduring power of attorney to deal with a lasting power of attorney for property and financial affairs. So, we're going to move on to the next slide. If there are any questions, please do ask, and we will pick those up at the end. And Holly is going to talk to you about lasting powers of attorney in general.
So lasting powers of attorney, there's two different types. So there's property and financial affairs and health and welfare matters. They're both pretty self-explanatory in what they deal with, but property and financial affairs can be things like paying taxes, bills, insurance, or things to do with investments. It essentially allows the attorney to do anything that the donor would be able to do in respect of their property and financial affairs. And then with health and welfare matters, it allows the attorney to make any decisions in relation to the donor's health and welfare. So things like what vaccinations they would have, or if they do have to go into a care setting, where they go. It can also allow them to have the authority to either give or remove life-sustaining treatment, if that is something that the donor allows them to do. And that authority can be given under the instructions and preferences, which is something Graham will talk more about in a minute. But essentially they can advocate for the donor as to what they think their health and welfare needs should be. The requirement for a certificate provider essentially means that it needs to be signed off that the donor has capacity when they're making the LPAs, and then they're not being unduly influenced by anyone who could potentially stand to gain something by acting as their attorney in either property and finances or in health and welfare. And there is a requirement for registration. They do need to be registered before they can be used. And the registration period with the Office of the Public Guardian is about 20 weeks at the moment. So we do recommend to all of our clients, as soon as they're signed, to get them registered. Otherwise, you end up having quite a big time gap between when they're actually needed and when they can be used. So with the property and financial affairs, they can be used while the donor still has capacity with their consent, whereas the health and welfare LPA can only be used once the donor has lost capacity. So that's a key difference to be aware of as well. And now I'll hand back over to Graham, who will talk more through the instructions and preferences.
Thanks, Holly. So the instructions and preferences are boxes within the lasting powers of attorney. Both types of lasting power of attorney have space and scope for people to insert instructions and preferences, and very broadly they will very much depend on the views of the donor or the person granting the power. We get asked to insert any number of different types of preferences or instructions which relate to a whole host of different elements of what the donor might think they may go through later in life, with no degree of certainty, of course, that any of these things will ever happen. One of the most common ones that people like to talk about is that they don't want their home to be sold unless it's absolutely essential, for instance, in respect of care fees and so on. And we need to be very mindful when we're including instructions and preferences into these documents to word them very carefully and to make sure that they either achieve what it is that the donor wants, or in some ways, even more importantly, do not hamstring the attorneys and prevent them from doing what is in fact in the best interests of the donor at the time. Because although one can consider a whole range of scenarios that might befall you if you start to lose your capacity, whether it be some catastrophic event or a slow decline into dementia or Alzheimer's, or even the situation where you have sort of locked-in syndrome and you have full capacity but you cannot communicate. Any of those are awful scenarios to contemplate. But until we're actually in those situations ourselves, or our attorneys are looking after us, we don't really understand fully what decisions they will or won't be able to make and what our needs will be at that particular time. So our advice in general is to try and reduce and keep as short as possible the list of preferences and the list of instructions, because we are concerned in general terms that they may hamstring the attorneys and not enable them to deal with the affairs of the person who's lost capacity in the way that they would have wanted them to, and indeed it may direct them to do something which could potentially manifestly not be in the best interests of the donor at the time. That said, there are some instructions and preferences that we do tend to include in both types of lasting power of attorney. And in respect to the property and financial affairs lasting power of attorney, we do generally include a provision in there that allows the attorneys to have access to a copy of the will if the donor has lost capacity. We find that's useful for attorneys because when they're managing the affairs of somebody who's lost capacity, if they can see in the will that, for instance, the premium bonds are going to be left to the grandchildren, the attorneys can make a decision to try and retain those premium bonds until later on in the process, rather than potentially encashing those to pay for bills early on. They can say, well, we'll try and safeguard those because we understand that the donor wanted those to go to a specific home, and it would be the same with any items of jewelry or adornment or photos or pictures, so rather than selling everything, they may take a view to sell other assets and to encash other investments other than those which are specifically left to individuals or groups of people within the will. So we find that's a useful one. And also with regards to the property and financial affairs, we use a provision in there in the instructions which relates to discretionary fund management schemes and allows your attorneys to continue to invest in the same. It's a real wordy mouthful. So if I explain that, if one were to have a stocks and shares ISA, you purchase your ISA every year with your ISA allowance, £20,000, and you are buying a very small slice of a rather larger pie, where there is a fund manager who is making lots of changes to that investment portfolio, that fund, on a daily basis, and sometimes more than once a day. When you sign up for your stocks and shares ISA, you are giving that fund manager the authority to make those decisions on your behalf, and to, for instance, sell the Rio Tinto shares and buy the Diageo shares or whatever. You don't get a phone call every day to say, oh, this is what we're doing, do you consent? And there's an element that some of the organisations who provide, for instance, those forms of stocks and shares ISAs, do believe that without the provision that we put into the lasting powers of attorney, and it's generally accepted that this is required now, they will turn that stocks and shares ISA into a cash ISA, because they don't believe that they have the authority, that delegated authority from the donor of the power to the attorneys to then continue making those transactions. And as such, it becomes unworkable for the providers of the powers of the ISAs, and as such they tend to say, no, we can't continue to do this, and we're going to turn it into a cash ISA, which of course has potentially a knock-on effect in terms of the income that the donor might receive towards their invoices, their bills, their care, their just life in general, and indeed the capital growth. So it's something that we do try and seek to avoid by inserting that provision into those. With regards to the health and welfare matters, we do generally sort of advise the donor that it's sensible for the attorneys to have access to their confidential medical records if they've lost capacity, because some people have fairly complex medical needs, and some of which would require treatment and intervention, and some of which would not, but present as though they may do. So we do ask the donors whether they're happy to include a provision in the health and welfare LPA to let their attorneys have access to their confidential medical records once they've lost capacity. We find that's also very helpful to allow the attorneys to have the information that they need to have to hand to help advise and make sure they're making suitable decisions in respect of the care and the treatment of any condition that presents in respect to the donor. So I think that sort of highlights the need for the instructions and the need for them to be well drafted. We have seen plenty that haven't been well drafted and are rather confusing. Sometimes the Office of the Public Guardian just won't register the power of attorney if they don't like the instructions or the preferences, but we do think that the ones that we advise as a general rule to go in are ones which allow the attorneys to continue to function to the best of their abilities, while also bearing in mind the confidential nature of elements of what are happening to the donor. So those are important. I think linked to the instructions and preferences, it seems that the greater need for instructions and preferences, and those where people come to us and say, well, I want to put lots and lots of different bits and pieces in my power of attorney, are those where maybe they don't know the attorneys quite as well, or they feel as though they maybe can't trust them quite as much because they're concerned they may do something which they wouldn't want them to do, and therefore they use an instruction or preference as a mechanism to try and prevent that from happening. I think our advice very much is that find attorneys who you absolutely trust, and Holly will speak about this a little bit more in a minute. Find those who you absolutely trust to do the right thing for you, and the need for the instructions and the preferences definitely does reduce significantly. So I think that's absolutely something worth bearing in mind when talking about the preparation and execution of lasting powers of attorney. And I'm going to move on back to Holly. I'm going to talk about who to choose.
So, as Graham's just said, choosing your attorneys is a very important decision. It's a big responsibility to give to someone. So we usually say to our clients to make sure they've had those conversations with people to make sure they're willing to act. It's people that they trust, and it's people that they know are going to be invested in their best interests. So this could be family members, although some people find that their family members are not the people they trust the most, so they wouldn't choose to go with them, and potentially pick a professional advisor instead. Obviously, there is a cost to choosing a professional advisor, but it does mean that it will be someone who has to act in your best interest. They're bound to make those decisions that are the best for you. And then we would say once they have picked attorneys, they could also pick replacement attorneys. This is important because if, for example, a husband and wife appointed each other as their attorneys, but then they both fell ill and weren't able to act, if there's no replacements, there's nobody to step in and make the decisions on their behalf. So we would say it adds an element of longevity if you have replacements that can step in, that you do still trust there is still somebody to make those decisions in the event that the first person appointed isn't able to anymore. There's also an important difference between joint appointments and joint and several appointments. Joint appointments means all of the attorneys have to act together in the decisions. So, for example, if there's a cheque that needs to be signed, they all need to sign the same cheque and they all have to agree on the decision. Whereas if it's a joint and several appointment, then one person can do the legwork while they report back to the other attorneys on what's happening, and it doesn't need to be all of them signing the same thing. This is also important because if, say, 4 attorneys are appointed on a joint basis and then one of them dies or isn't able to act for whatever reason, they can no longer act jointly. So then they aren't allowed to proceed with that appointment. Whereas if it's joint and several and one person dies or can't act, then the other attorneys are still able to act on the donor's behalf. So it's an important distinction to make and to make sure the clients are aware of when they're drafting the LPAs in the initial stages. As joint and several would make it a bit more flexible for them. So yeah, something key to be aware of there.
And that is really it from what we were trying to convey this afternoon. We're going to have a look and see in the chat to see if there are any questions, of course. So bear with us while we try and get the chat up. Here it is. It's just opening. Right, at the moment, we don't have any questions. We'll wait a couple of minutes. So please do feel free to put any questions in there if you have any. Of course, if you've got something better to do, get on with the rest of your day, then please do feel free to leave. We're not going to be sharing any more information other than answering any questions that people may ask. We have got a question coming in. We've got 2 questions coming in. It's exciting. Okay, so we have a question as to who can act as a certificate provider. Does it have to be a professional or can it be a close friend? That's a really good question. It does not have to be a professional. It needs to be the actual power of attorney document says in it who it can be. They used to be much more prescriptive. It had to be somebody who knew you for a significant period of time, and there had to be somebody who was known to you outside of whatever your area of profession was. But professionals do it. So certainly when we are acting for people for lasting powers of attorney, we act as a certificate provider because we're trained to assess capacity and make sure that people understand the documents that they're signing. And of course, we've had a couple of meetings to run through all the various elements of the powers of attorney. So we absolutely do act for people. What we wouldn't do is we wouldn't generally act for somebody as a certificate provider where the document's been prepared by somebody else, because we don't know that individual and we don't know the contents of the document necessarily. It does not need to be a professional though, so it can be a friend or a next door neighbour, and the precise requirements are on the certificate provider page of the LPA, but they obviously need to be somebody who's over 18, who's of sound mind and everything else. But no, it doesn't need to be a professional. So thank you for that question. We then have a question about the purpose of replacements if two or more attorneys are appointed in the first place. Right, so would you like me to take this one?
Yeah.
Yeah. So if you have two or more attorneys appointed in the first place, that's completely fine. We always think that it's helpful to have a replacement or two, because one doesn't know if you we have clients who, for instance, maybe don't have children, but they have siblings, and they may be appointing their siblings as their attorney jointly and severally, and that's fine. But naturally, as they go through life and they get older, their siblings will be going through the same situations that they are going through themselves, and they may not be able to act. So we would then say in that scenario, it's useful to have another replacement, or have a replacement or more from the next generation or two down, so that you have that longevity of appointment of people that you have chosen. That said, if, for instance, you are a parent and you've chosen your two children to act as your replacement attorneys, or attorneys in the first instance because there's no surviving spouse, or the spouse is incapable, or you don't trust them, or you're no longer married, then it is fine to have just the children as the attorneys jointly and severally. But we always encourage people to consider that position around the replacements, about whether they think it is something which is relevant to them. And some people do and some people don't. But no, John, appreciate that question. Thank you very much. And we've got a question come in as well. Can you replace an attorney for health and welfare if they are no longer able to act? So that question comes from Louise. Louise, the answer is you can, but it's not very straightforward. If the donor of the power has still got capacity and they would like to change who the attorney or attorneys are because they have capacity to do that, but the attorney or attorneys don't have capacity, then they can absolutely do that. And they don't have capacity. Thank you. So you have a situation where a donor has lost capacity. You have health and welfare attorney who is no longer able to act. It will depend on whether there are any replacement attorneys or substitute attorneys, same thing. They would be able to act in view of the person who has lost capacity. There would be a requirement to evidence the loss of capacity of one of the attorneys to the Office of the Public Guardian, and they would effectively remove them from the document which is in force currently. If there is only one attorney and they have lost capacity, then there is no mechanism to amend a lasting power of attorney after it has been registered and after the donor has lost capacity. That would then require an application to the Court of Protection for a deputyship order or an order for a specific medical purpose if there was one particular decision that needed to be made. So if the donor has lost capacity, and if the attorney or attorneys of all as a group, whether it be one or more, have lost capacity, then you would need to make an application to the Court of Protection if there are health and welfare decisions to be made, because there is no mechanism to amend the lasting power of attorney after it has been registered, or after it has been signed in reality. But once it's been registered, you can't amend it either. You would have to do a new one. And if the donor doesn't have capacity, then they can't make a new one. So I'm afraid that would be a Court of Protection application. And I see that you say that's what you think. that we're at. So I'm sorry to say that seems like that is the most likely outcome. If anyone else has any questions, no, you're very welcome, Louise, no problem. If there are any other questions, please let us know. We will hang around for another couple of minutes, so please just do feel free to ask if there's anything that you'd like to know that we might be able to help with. Otherwise, in a couple of minutes, we'll say goodbye and we'll end the call. Thank you, Megan. You're very welcome. Thank you, John. Thank you, Sandra. Right, doesn't look like there are going to be any other questions, guys. So please, if you do have any, feel free to reach out to Holly and I, and we can do what we can do to help with that. But in the meantime, I wish you all a very happy rest of your Monday. Thanks very much.
Thank you.
Goodbye.